Yes, Mr. Paul.
Please you, my lord. I appear on behalf of the appellant in this matter, Mr.
Indeed.
Chapman, on behalf of the respondent.
Yes, I can tell you that we've read the 3 decisions of the FTT and the 2 decisions of the Upper Tribunal.
Yes.
And we've read, of course, the skeleton arguments.
Yes, I'm grateful. There is one, so hopefully you will also have then an appeal bundle, a supplementary bundle, and a authorities bundle. There is another bundle which has made its way to your desks, for which I apologise, namely a supplementary authorities bundle.
Yes.
And I shall take you to that briefly in due course. My lords are plainly aware this is an appeal against the decision of Upper Tribunal Judge McWilliam, dated the 24th of February 2021, that overturned and set aside the decision of First Tier Tribunal Judge Clark, dated the 13th of March 2020.
Yeah. As I've understood it, if she was entitled to overturn the FTT decision, you don't appeal against her substantive decision.
Leave has not been granted on that. Yeah. So there is one ground before you, which is the way it was advanced in the grounds was the Upper Tribunal erred in law by finding a material error in the FTT's assessment of credibility. To put it another way, perhaps a simpler way, the error of law is that there was no error of law in the FTT's decision.
Yes.
And for completeness, the 5th authority in the supplementary bundle I've handed up, KB Jamaica, is an authority where the error of law was couched in precisely those terms. My lords, I'm sure you have the chronology well in mind.
Yeah.
But I do propose to just draw out a few salient features, if I may, because the chronology is of relevance to the overarching issue of delay in this case. So if my lords and lady will permit me, if I could briefly address you on that first. Plainly, the appellant came to the UK in 2006. He came lawfully on a visit visa and was then granted 5 years leave under what is known as the Ankara Agreement. Subsequently granted indefinite leave to remain in 2011, again on the basis of the Ankara Agreement. And it is the appellant's submission that he entered lawfully and at every stage has been in the UK lawfully. And as far as Section 8 purposes are concerned, that is potentially of relevance. Because this is not someone with a history of clandestine entry or any of the other factors which can be taken into account as potentially damaging credibility under Section 8. He has 3 children here, aged 14, 12 and 9. His wife sits alongside him at the back of court. Just for completeness, I noted in preparing this that the Secretary of State decision, for your reference, it's page 138 of, I think, the core bundle, is actually wrong in the date of birth of the eldest child. He was born on the 22nd of September 2008, not 2012. But nothing turns on that. But of course, the reason why the appellant is before you is because of what happened in 2014 and the index offence, to which he entered a guilty plea and was sentenced to 14 months.
And that was Section 20, not Section 18, wasn't it?
Yes.
Because the Upper Tribunal Judge, I think, got that wrong. I think she actually says GBH with intent. I think that's wrong.
Yes.
It was Section 20.
But it was GBH, just without intent. The background to that offending is set out in my skeleton.
Yes.
So, whilst he is on bail in relation to those proceedings, he goes to Turkey, and he goes to Turkey in December 2014. His family had gone there to celebrate New Year, and my lords and my lady will be aware that in December 2014, when he entered Turkey, he was pulled to one side at the airport, and then he describes having been beaten up and received rough treatment, in which he was insulted and assaulted, and describes...
There's no suggestion at that stage that that was anything to do with his Gülenist sympathies. or his connections with the Gülenist movement, and of course it was pre-coup, wasn't it?
My lady, that's right.
So he's subjected to some nasty treatment by some maverick officials in Turkey, but allowed to continue with his connecting flight, and then that upsets him. Doesn't stay with the rest of the family for his holiday, but he does go back and pick them up. Goes back through the same channel at the airport without further incident.
Exactly, my lady.
See, we have read the papers.
I would not have expected otherwise, and I apologise if I'm labouring ground unnecessarily at any point, but I shall be guided by the court. Suffice to say then, sentenced to 14 months in July 2015, and the decision to deport is the 18th of July 2015. The human rights representations were made, and it's right to point out that at that stage they weren't made on the basis of him being a Gülenist. He has his youngest child, M, who is currently 9, has special educational needs.
Yes.
Those representations were refused the 4th of August 2017, and First Tier Tribunal Judge Cameron refused his human rights appeal on the 13th of August 2018. And then the summons, which the appellant says crystallises his asylum claim, is dated the 11th of September 2018, and he claimed asylum on the 4th of October 2018. And so just to complete the picture, he became appeal rights exhausted in relation to First Tier Tribunal Judge Cameron's decision on the 28th of September 2018. And my lady and my lords will be aware that the coup occurred on the 15th of July 2016. And we can see, as and when we come to it, that there was a state of emergency declared in Turkey following that coup between the 21st of July 2016 to the 19th of July 2018. So it ended not long before the summons was issued. There are 5 principles which I say are of particular relevance in guiding your decision in relation to this case. And they are contained in part in the supplementary bundle and in the main authorities bundle. The first principle, all of these will be well known to the court. The court should not be astute to characterise as an error of law what is in truth no more than a disagreement with an assessment of the facts. And my lords and lady, if I could take you to that supplementary bundle. The first authority there of MA Somalia.
Yeah, I think that's plain, that if there is a disagreement about the facts, then that's a disagreement about the facts, and
yes.
That's that. I mean, the case you have to meet is nothing to do with, if you like, issues of law, issues of fact. The case you have to meet is that there is an obligation on any tribunal to give adequate reasons for its decision. The main point taken by the Secretary of State was that there was a significant delay between the ill treatment in December 2014 and the making of the asylum claim. The making of the asylum claim came after the rejection of the human rights, etc. claims, and that the FTT judge, although the FTT judge considered whether there had been some sort of mix-up over the date when your client was in Turkey, never actually addressed the main point of the Secretary of State's case, namely there was something like a 3-year delay.
Well, yes, that is the case I have to meet. I'm not entirely sure that the way the delay is put is necessarily that it all hangs on the incident in 2014, because it's not the appellant's case, but as at 2014, he was at real risk of persecution on the basis of his membership of the Gülenist Movement. No. And indeed, the Gülenist Movement...
It comes to light after the treatment of the
Yes.
Gülenists following the coup.
Exactly.
Yes.
Which was very well publicised. It must have been very well known to every member of the Turkish community.
It was the real nub of the Secretary of State's case is about the fact that he didn't claim asylum basically at the time when he made his human rights claim. And that, I think, is the real nub of it.
My lady, yes, and I think what really rings alarm bells here, in the Secretary of State's ears, and no doubt in the court's ears, is the coincidence of timing of the appellant claiming asylum very shortly after becoming appeal rights exhausted.
Yeah.
Yes.
And that really is the nub of this case and the concern of this case. And whilst there is obviously talk of delay, because that is the way in which it is properly framed in Section 8, really it is in part delay, but it's really question of coincidence of timing, which is the underlying concern, which obviously is related to delay.
Well, the two,
they go hand in hand.
Yeah, they go hand in hand. They're almost two sides of the same coin.
They are.
But you see, if the First Tier Tribunal judge had said, hypothetically, I appreciate that you can't really complain about any delay after 2014 because at that stage he wouldn't have perceived that he was under any sort of threat. But there was plainly a need for such perception at the time of the summons, at the latest, with all of the consequent publicity about the Gülenists and what was going on in Turkey. And at that stage he didn't claim asylum. However, having seen and heard him, he gave an explanation for that delay, and I'm satisfied with his explanation, which was this, this, and this. Then we wouldn't be here. And the real problem is that the judge didn't do that. The judge didn't put forward anything that was heard about the explanation, and doesn't actually address the point about that delay. He sort of seems to have gone rather more, or she, seems to have gone much more for what was going on in 2014 and 2015, which isn't really relevant to the relevant delay.
My lady, I would accept that the judgment could potentially have been better expressed in places. But when looking at the issue here of sufficiency of reasons, which my lord indicated is obviously front and central to this case, if I could take you to the second principle, which again I don't think will be in dispute, the authority of R and Jones, the second in the supplementary authorities bundle, on page 34 of that.
Yeah.
In the bottom of page 34, in paragraph 35, 4 lines up from the bottom where it's highlighted, it is well established as an aspect of tribunal law and practice that judicial restraint should be exercised when the reasons that the tribunal gives for its decision are being examined. The appellate court should not assume too readily that the tribunal misdirected itself just because not every step in its reasoning is fully set out in it. And so too, the third principle and the third authority, UT Sri Lanka, page 45 of the supplementary bundle. Looking in paragraph 19 on page 45. Again, where it's highlighted. Secondly, although error of law is widely defined, it is not the case that the UT is entitled to remake the decision of the FTT simply because it doesn't agree with it or because it thinks it can produce a better one. No. And of course, as I say, it may be the case that the judgment of First Tier Tribunal Judge Clark could have been better expressed in areas, but that, in my submission, is not enough to amount to an error of law.
The question is whether it's sufficient.
Yes.
There's plenty of authority, but judgments could always be better expressed.
Yes.
We spend a lot of time reading.
Yes, well, of course. This court is preeminent in that.
It's very easy on appeal to say that things could have been done better. The question is whether the First Tier Tribunal has reached the minimum necessary adequate reasons for the decision. That's the question.
My lord, it is, and it has to be looked at through the prism of what Section 8 requires, because that, of course, is what is pinpointed as the error of law. So if I could take you to that as my fourth principle, And if we could turn up the authorities bundle and the case of JT Cameroon behind tab 9. So tab 9 is on page 133. And the facts, very briefly, of JT Cameroon. This was an appellant, or a couple of appellants, who arrived with false papers. The tribunal dismissed their appeal on the basis of applying Section 8. And the Court of Appeal allowed the appellant's appeal, finding that Section 8 was part of a global assessment of credibility. And we can see there in the head note, allowing the appeal on a true construction, although Section 8 factors should be taken into account in assessing credibility and were capable of damaging it, the section didn't dictate the relevant damage to credibility inevitably resulted. No. Section 8 is to be read with the qualifying word potentially were inserted. And that since there was a risk that the tribunal had given the Section 8 matters a status and compartment of their own, rather than taking them into account as part of a global assessment of credibility, as they should have been, the case would be remitted to a differently constituted tribunal. And so, accordingly, if I can ask you to turn up paragraph 16.
Yeah.
At the bottom of page 138, which is that reference to compartmentalising we saw in a head note. I do not, however, agree with the parties that there is a real risk that Section 8... I do, however, agree with the parties that there is a real risk that Section 8 matters were given a status and a compartment of their own, rather than taken into account, as they should have been, as part of a global assessment of credibility. And it's the submission of the appellant here that where the Upper Tribunal has fallen into error is by demanding of Section 8 something which is not required. It should not be given a status and a compartment all of its own.
The bit of Section 8 that's relevant is, as you put it, the coincidence between the asylum claim and exhaustion of appeal rights.
Well, yes and no, in as far as the only statutory criteria is delay.
Yes. Right. So where does the FTT judge take that into account?
My lords, let me take you through the FTT decision in detail. So if we could turn up tab 12. It starts in my submission on page 104. So page 103 is the beginning. Mm-hmm. Paragraph 5. The judge sets out the application was refused on the 1st of February 2019 and is the subject of appeal before me. The thrust of a refusal is that this is a late claim for asylum. It is plainly at the forefront of First Tier Tribunal Judge Clark's mind that there is an issue of delay at large in this case. An issue of delay, which means that she needs to form a holistic assessment of credibility to determine whether that factor of delay is potentially damaging and actually damaging to the credibility. And she goes on in paragraph 6, setting out what in effect is the issue and background of that delay. By way of background regarding the timing of the asylum claim, and she describes how he was subject to the conviction in 2017 and then the subsequent appeal, and then 3 lines up at the bottom. The appeal was dismissed in a decision of Judge Cameron on the 13th of August 2018, and the appellant became appeal rights exhausted on the 28th of September 2018. So she sets out the context then and explains how this claim has come to be made after the appellant was appeal rights exhausted.
Yeah.
And then over the page, we have her findings of fact and conclusions. And the first point she makes, one in the appellant's favour in that assessment of credibility, is that he was broadly consistent. However, she identifies that there was one discrepancy. And that discrepancy was in the year when he says he was detained. And he clarified that there was only one occasion on which he was detained. The discrepancy is that in the first witness statement, it read 2014, whereas in the second statement, it read 2015.
Right. So what was his statement? What was his explanation?
He went there in December 2014, and then he is detained at the airport, and then he is terrified by the treatment that he receives there. He goes back to the UK, his family have their holiday in Turkey, and then in 2015, he goes back again. So it's both. The statements aren't wrong by saying that he went in 2014 and then went in 2015. He went in December 2014 and then went back in January 2015.
What was his explanation in his statement for the delay?
I don't think we have the...
The way the submission is going, it
Yes.
sounds as though what you're saying is, well, the FTT accepted his explanation. What was it?
Well, there was a discrepancy. I see, my lord. I'm trying to deal with the discrepancy because it's a discrepancy which has been identified as being potentially damaging to his credibility. I mean, his account on the delay is that I claimed asylum when I got the summons. So that's his explanation to that, but it doesn't help him with why he's produced one witness statement that says he went to Turkey in 2014 and another in 2015. But his explanation to that is that it was both, and this fell over the new year of 2014-2015. So turning back then to paragraph 9, we can see at the bottom of that paragraph, the judge notes, I have considered the discrepancy in the year in the round, noting the holiday took place over New Year's. So at that stage, she's not yet forming a concluded view on how damaging that discrepancy is. She's simply noting that he said 2014, said 2015, but it did happen over New Year. Yeah. And then paragraph 10, she goes on and makes some, not trenchant criticism, but there is some criticism. There is, in my submission, not uncritical acceptance of aspects of his account. She observed that he hasn't provided much in the way of evidence, which may have been available. No evidence of the Asya bank account, which is something we can turn to. Nothing from a hospital to confirm that his father was hospitalised. No evidence from a sister or mother confirming it. No medical evidence. Then the last line, the appellant hasn't tried to exaggerate his claim. I have considered this in the round. So there are things which are lacking, but I accept, and presumably this was also on the basis of his oral evidence and the view she took of that he isn't someone who has sought to over-egg his case. And then paragraph 11, having identified that there are areas of evidence which are missing, the judge goes on to consider some of the potential reasons behind that missing evidence.
Yeah.
And one of those is that the appellant said that the sister told him that after the authorities visited and harmed their father, communication between them would cease. So she considers the explanation that there was nothing from the sister because the sister was worried about what might happen. And then 3 or 4 lines up from the bottom there, given the outlawing of the Gülenist movement, it is unlikely that the appellant could obtain evidence from his schools where he studied and worked. So again, she considers and weighs up why there is no evidence about his employment. And she ultimately considers, it would appear, that there is nothing, the fact that there is nothing from them is reasonable. And then it is paragraphs 12 and 13 which engage with the issue which is potentially before this court, or which is before this court, is to delay stroke suspicious timing. Paragraph 12, the appellant delayed claiming asylum until after the dismissal of a deportation appeal, in which he raised human rights only based on his family and private life. This is relevant in regard to the discrepancy in the 2014-2015 date of his claimed detention. Given that it is explained because it fell over the New Year's holidays, I find less damages caused his credibility by the delay in claiming asylum. So what the judge is doing here, and I can see the face which...
well, it's apples and pears, isn't it? There's a disjunct between the beginning of the sentence and the end of it.
Well, in my submission, it is understandable that the judge has identified a discrepancy, and then she has also identified delay. And what she is doing in this paragraph is weighing up what is the impact of delay on this discrepancy. Is it something which means that I should believe less what this appellant says, or is the impact of delay on this discrepancy and its consistency overall something which I needn't be significantly concerned with?
However you look at that particular passage and however sympathetically you look at it, what it's not doing is saying, I accept the explanation he has given for the delay was that he didn't fear for the way he would be treated on the way he returned to Turkey until he got the summons.
Well, my lady, I think that's because it is recognised, and it wasn't the appellant's case, that he was seeking asylum in 2014 when the coup hadn't even happened and the Gülenist Movement weren't...
So how can it be relevant? How can the delay be relevant to the discrepancy in the 2014-2015 date? It seems quite irrelevant.
No, because delay is only relevant in as far as it goes to credibility. So what the judge is doing is looking at the one hand at the fact that there is a discrepancy which undermines or potentially undermines the appellant's credibility, and is then taking that issue of the discrepancy and weighing it alongside the impact of the delay. That is what paragraph 12 does. And the reason why really the underlying concern here is of suspicious timing is important is because it really all hinges on whether or not this arrest warrant should be considered a valid warrant. If it is accepted as a valid warrant, a valid arrest warrant, then it is understandable as to why the appellant is claiming asylum in 2018 at the point at which he's become appeal rights exhausted. Because the matter has crystallised, giving rise to him being sufficiently frightened as to claim asylum.
Well, I agree with all of that, which makes it all the more surprising that you don't have an FTT judge expressly addressing that point.
Well, in my submission, we do.
It actually turns on, she doesn't mention the arrest warrant at all.
My lady, if I could direct your attention to paragraph 13,
Yeah.
4 lines up from the bottom, the summons issued is consistent with the timings. And there we have directly the issue which looms large in this case as to whether the First Tier Tribunal judge thought this was all a ruse, whether they actively considered the genuine nature of the summons, or whether they considered it against the background evidence and the evidence given by the appellant. And here the judge unimpeachably considers it against the background evidence in and around and decides that it is consistent. The summons issued is consistent with the timings because there was a mass roundup of people considered GM sympathisers. Whilst the mass roundups were in 2017, I accept the submission of Mr. Ball that they didn't just stop in 2018. In other words, the judge considers that this summons being issued in September 2018 is consistent with the background evidence. It is consistent with the appellant's evidence, evidence which she considers to be consistent internally, save for one discrepancy. that anomaly about 2014, 2015. And that is why paragraph 12 maybe doesn't read particularly elegantly, but that is why it concludes, I find less damage is caused to his credibility by the delay in claiming asylum, because she is looking at the discrepancy that she has identified, and she is weighing the issue of delay as against that discrepancy.
I still don't understand where the delay comes in relation to that discrepancy. The discrepancy is one point, but on any view, it was not your client's case that he feared for persecution in 2014, 2015. And his case was, I made my claim when I did because of the summons.
Yes.
So when she's looking at delay, she would be looking at it in that context and not in the context of what happened in 2014, surely. At the moment, I don't understand paragraph 12 at all. I've read it many, many times, and I still don't understand what she was getting at in that paragraph. You say it may not matter because she's actually said what needs to be said in paragraph 30.
Yes, and I think there is a danger of not taking a judgment holistically and in the round, and zeroing in on a paragraph which I accept could have been better expressed, but the real question is whether or not the judge has erred in her treatment of Section 8. And as we saw in JT Cameroon, Section 8 does not require the issue of delay to be compartmentalised. No. It is to be treated in the round, and the judge has done that. She has looked at the evidence in the round. She has considered that the summons is genuine, and she has considered that the appellant is credible.
So essentially what you're saying is that she set out the history of the matter in a way that makes it very clear that she is alive to the fact that the main issue is the timing at which the asylum claim is made, and the coincidence of the timing.
Yes.
She then looks chronologically at what happens in, she looks at his evidence in the whole in terms of credibility and internal consistencies. She says there's one inconsistency in relation to 2014, 2015. I'll identify that. I'll identify the explanation for it and park it.
Yes.
I'll then have a look at other matters like the documentation to support his account. I acknowledge that there's certain documents that are missing. I'd take into account the explanation for that. So that's all looked at. Then looking at the whole of the position, I look then at the timing of the summons and whether that's credible and stacks up. And yes, that stacks up. And putting it all together in the round and taking into account the delay, I decide that he's telling the truth.
My lady, yes.
That's really what you're saying. And it may be imperfectly expressed in paragraph 12, but you say you can't divorce that from the holistic looking at the whole of her reasoning.
Yes, and more than that, that is what Section 8 requires. Section 8 does not require a delay to be hived off.
No.
But leave aside Section 8 for the moment.
Yes.
There is a dispute between the Secretary of State and your client. And the tribunal must give its reasons for resolving that dispute in a way that allows, in particular, the losing party, here the Secretary of State, to understand why she lost.
Yes.
And if you look at the refusal letter, page 134 of our core bundle, paragraph 27 says, you only raised your claim for protection after you were served with a deportation order, failed to raise your protection claim at the earliest opportunity. You could have raised your concerns at any time following the coup in 2016, you haven't done that. Should have raised your concerns in 2018, but you haven't done that either. You only raised it after you faced deportation. That's the big issue in the case. Where does the FTT deal with that issue? Never mind Section 8. The duty of the tribunal is to give reasons on at least the important points of dispute between the parties, and that applies up and down the country, not just to immigration tribunals, but to planning inspectors and any sort of court or tribunal. You've got to deal with the main issues. And where does the FTT judge deal with that issue?
My Lord, the FTT judge was plainly aware of this issue from paragraph 5.
Well, maybe, but where does she give her reasons?
My Lord, it resolves down to whether or not the summons is genuine. Because if the First Tier Tribunal judge considered that the summons was genuine, the way the case was advanced, and I represented the appellant at the First Tier, as I have done throughout, was that it was the summons which crystallised his asylum claim.
Right, and the summons was, just remind me?
About 3 weeks before he claimed asylum, as I recall it.
Yes. I'm grateful. The 11th of September, 2018.
Yeah.
Thank you.
And the asylum claim the 4th of October.
Yeah.
And the previous refusal from First Tier Tribunal Judge Cameron the 13th of August, 2018.
Right.
So, my Lord, to address your question and concern, I can do no better than point both to paragraphs 12 and 13, where in paragraph 13 the judge squarely considers the question of the summons and identifies that it is consistent with the timings, her words.
Yeah.
And so there is sufficient reasoning for the Secretary of State to understand why the case has been decided against her.
Well, you say paragraph 13 says, in effect, I accept this is a genuine summons because it's consistent with the timings, it's consistent with him, I find he's credible, therefore he's telling the truth when he says, I didn't claim asylum until when I did because it was the summons that crystallised it. That's a necessary inference, you say, that can be drawn from that.
Yes.
Yes.
And it does not involve any leaps of faith in my submission. There is no gaps in the reasoning. There is reasoning which I accept could have been potentially more clearly expressed, but it is more than sufficient. It is certainly nothing approaching the threshold of perversity, which is what the Secretary of State seeks to suggest at points in the Secretary of State submissions.
I'm not sure that is what the Secretary of State says.
Obscure to
reasoning.
Yes, yes.
That's not the same. That's not the same as perverse.
Well, perverse is a word which features in the respondent's skeleton.
Right. Well, that's
perhaps I do Mr. Chapman a discredit. Irrational, completely incoherent, irrational.
Yeah, it's really incoherent.
Incoherent is perhaps more. Yes.
It could have, in places, been more coherent, but looking at this judgment in the round, it is obvious, as I've indicated, that the judge had this issue squarely in mind. It is obvious that the judge believed the appellant, and she was entitled to believe him. And she has given clear reasons for believing him. And more than that, she has given clear reasons that she considers the summons to have been a genuine one. It follows from that there is an explanation as to why he claimed asylum then.
Can we just see where the appellant says that it was the summons that triggered the application?
My Lords, I'm looking at the supplementary bundle and the appellant's statement behind tab 4, but I cannot see anywhere where it is clearly expressed there.
Sorry, I haven't got tabs in this one.
I apologise. Page 80. At page 88, we have comments on the reason. Yes.
Is that in the core?
No, in the supplementary bundle.
Sorry, supplementary. Forgive me.
Well, here you've got a refusal letter, and one of the big points made in the refusal letter is you could have made this claim. You had at least 2 opportunities to make this claim, and you didn't take them.
Yes.
And you say, well, the answer to that is it was the summons that triggered it, and I wasn't really fearful of persecution until I got the summons.
Yes.
And where does he say that?
My lord, I don't have my skeleton argument from before the first tier to see how I put the case there.
Well, no matter how you put it, where's the evidence?
Nor do I have a note of the evidence that was before the first tier. What we have is that statement.
And the FTT judge doesn't say that it was the summons that triggered the application. You're quite right to point out, she says the summons, the timing is consistent with the summons.
Yes, but it's not the appellant's case that he was at risk in 2014, 2015 when he was stopped.
I understand that. You say it was the summons that triggered the claim.
Yes.
But just looking for.
I can't assist you.
He doesn't say it in his witness statement, does he? I mean, I've just gone through it again. But that's the one thing he doesn't say. He says that the coup took place in 2016. He says that there's a risk because of that. But he doesn't say anything, actually, about the summons.
No.
Respectfully.
And he's asked to comment on the reasons for refusal at page 88, and that was one of the big reasons for refusal, which he doesn't comment on. Yeah.
My lords, we've looked at some detail at the FTT's treatment. I wonder if we could also perhaps briefly look at the Upper Tribunal's treatment of the error of law decision. So if I could invite you to turn up page 85 of the core bundle. Judge recites principles set out before this called A.H. Sudan, paragraph 22, well-established principles in Low, paragraph 23. And then about 5 lines into paragraph 23, the judge, there's a sentence beginning, while I accept that the judge gave 3 reasons for allowing the appeal, he, I interpose she, did not resolve a significant issue raised by the Secretary of State, which was the issue of delay. This was of particular significance in this case because of the history of the appeal. It's an issue clearly raised in a refusal letter and relied on by the Secretary of State. It cannot be understood from a decision what the judge made of the delay and whether he applied Section 8 of the 2004 Act when assessing credibility. Simple acknowledgement of the delay is insufficient. I submit that that is not a fair reading in the round, in particular of paragraphs 12 and 13. We're looking at the judgment as a whole, because the judge, as I've highlighted, paragraph 5, sets out the issue of delay, addresses it by comparing that factor of delay as compared with the identified discrepancy.
Yeah.
Because the judge goes on in para 24 to deal head on with your argument. It cannot fairly be implied that the judge accepted the appellant's explanation because she found that the timing of the summons was found to be consistent with mass roundups.
Yes, and then it goes on. The point being made by the judge at paragraph 13 is that the summons was not out of the blue. This was a finding concerning the reliability of the summons and not the reasons for the delay in making a claim. While I understand that there is a connection, it was incumbent on the judge to consider the delay in making an application on protection grounds and the appellant's explanation that the trigger, there we have it, that the trigger for the claim was the issue of the summons, and made clear what weight should be attached to the delay. Whilst there have been criticisms of elements of obscurity about the First Tier Tribunal's reasoning, in my submission there is a real obscurity about the Upper Tribunal observing that there was a finding concerning the reliability of the summons and not the reasons for the delay, but also understanding that there is a connection. Well, that's why this all becomes somewhat circular, because the explanation for the delay resolves down to the reliability of the summons. So it is difficult to understand the Upper Tribunal judge's reasoning here. If the Upper Tribunal is saying, well, okay, I accept that the First Tier judge has considered and made a finding on the reliability of the summons, and I accept that there is a connection, but there hasn't been an explanation of the reasons for the delay.
What she's saying is that if the judge had gone on and said, I find that the summons is reliable, and in the light of that, it is perfectly understandable why the appellant did not bring his asylum claim until the time that he did, then that would have been one thing. But she doesn't say that, and therefore the whole thing is left hanging in the air.
Well, it's not left hanging in the air in my submission, given the finding that the observations at the outset, that she's aware of the issue of delay, aware of the issue of suspicious timing, and then she finds that this is a genuine summons.
Yeah.
What I say is that when the Upper Tribunal says it was incumbent on the judge to consider the delay in making an application on protection grounds, what this Upper Tribunal judge is doing is falling into precisely the trap that is identified in JT Cameroon of requiring Section 8 to be in its own box, in its own compartment, rather than taking it into account as part of a global assessment of credibility, which is what the judge, unimpeachably in my submission, has done. There is a legal footnote there. If I could ask my lords and lady to turn up the large authorities bundle, there is a late entrant, there is hopefully a late entrant to that, and the inside leaf of the authorities bundle, there should be, my lord, yes. So we can see...
the tribunal must now actually give its reasons explicitly.
Not yet, not yet.
But when it's brought
So when it is brought into force, yeah.
Yeah.
So, as and when Section 19 is brought into force and then the Tribunal Procedure Committee amend the Tribunal Procedure rules, my case might be on a different footing.
Yeah.
But that is not the position as it stands. My lord, it's perhaps worth looking just very briefly at matters through the other end of the telescope and considering what exactly did the Upper Tribunal judge accept after having found that there is an error of law. The Upper Tribunal obviously go on and make their own assessment of credibility. The Upper Tribunal, and this is the case accepted by the Secretary of State, if the appellant is a member of the Gülenist Movement, it is accepted that he would be at risk. And the Upper Tribunal accepted that the appellant was detained and, by extension, it would appear, accepted that he was tortured as claimed. It's paragraph 62 of the Upper Tribunal's judgment.
This is the substantive decision.
The substantive decision. So the Upper Tribunal accept that. They accept that he had a bank account at Bank Asya. They accept that he was a committed Gülenist when he was still in Turkey, up until 2006 when he left. So this is not, in my submission, which even on what I say is an assessment of credibility which should never have taken place, there are fundamental planks of the appellant's case which are simply not in dispute. But the issue for you to consider, the issue which is in dispute, is that question of sufficiency of reasons in relation to the first tier. And in my submission, looking at it in and around, there is a sufficiency of reasons. And it is quite obvious that the consequences for this appellant are potentially profound if it is considered either way, that reasons are either sufficient or insufficient. It is not an irrational or incoherent judgment. I accept there are elements where it could have been potentially more coherent. Final authority, if I could take you to, in the authorities bundle, the large one, page 164, tab 11.
Yes.
KB and AH. We only need to turn up the first headnote. This is the Secretary of State's own guidance on how credibility should be assessed. And we can see that what is considered to be the guiding lights on page 164 are sufficiency of detail, internal consistency, external consistency, and plausibility.
Sorry, what you're looking at?
So I'm on page 164, paragraph 1,
Yeah.
the credibility indicators.
Yes.
Then it sets out assessing credibility and refugee status, which can be summarised as comprising sufficiency of detail. Those are the hallmarks, the guiding lights with which the Secretary of State herself assesses credibility.
Yes.
And that is why I say the judge has adopted the right approach in the First Tier Tribunal of looking at the internal consistency of the appellant's account, identifying that one discrepancy of 2014-2015, and then that is why it is that one discrepancy which has been weighed against the factor of delay in paragraph 12. That is what is going on there. And in any event, the judge found that the summons was externally consistent. Just a couple of last points to pick out from the First Tier Tribunal decision, although we've looked at it already in some detail, right towards the back of the decision. Paragraph 15, which is really the summation of the judge's conclusions, page 106. The judge finds that the appellant studied at a Gülenist Movement school, undertook his military service, turned down the offer of a naval scholarship. He taught at a GM school, has lived in the UK since 2006, travelled to Turkey on a number of occasions until 2014-2015. And looking at the facts in and around, there is a reasonable likelihood that he would prompt suspicion from the Turkish authorities. Further, given the appellant and his wife have been consistent, so again, in line with KB, the judge is looking at consistency as a hallmark, which is why she's troubled by the inconsistency in paragraph 12 and the impact the delay has on that. I accept that he held a bank account with Asya Bank, he ran a Bylock encrypted communication app on his phone, and he has donated money towards the Gülenist Movement and kept informed of the movement in small discussions in the UK and some Twitter activity. All of this is of relevance because it is what the Secretary of State herself identified as being potentially relevant in the country policy information note That appears in the supplementary bundle. It's page 136 of the supplementary bundle. The bottom of page 136 in paragraph 6.10.1, right at the bottom of the page, other risk factors, a quote from the New York Times, and the authoritative source sets out that at present several pieces of evidence can suggest that you may be a member of FETO, that's the parallel state or another name for Gülenist, including having had a bank account at Bank Asia, which was founded by Gülenists, running the Bylock encrypted communication app on your phone, which have facilitated the planning for the coup, possessing F-series dollars, that doesn't apply, sending your children to a school, that doesn't apply, working at a Gülen-affiliated institution. So there are a number of factors which have been found such that this appellant does have a real risk of being treated and identified as a Gülenist, does have a real risk of persecution, and more importantly, there is a sufficiency of reasons in my submission in the FTT's decision as a whole, once it is accepted and properly recognised, that Section 8 is not to be put in its own box and compartment, unless if I can assist my lady or my lords further.
Thank you very much, Mr. Ball. We're going to rise for a few minutes just to take stock.
That's not a good time.
Yes, Mr. Chapman.
My lords, my lady. I'll be brief. The starting point is that it's not in any doubt that the First Tier Tribunal Judge could lawfully have allowed the appeal.
Yes.
And in doing so could lawfully have concluded that there was a perfectly good explanation for the delay. And by that I mean not making the claim, the asylum claim, earlier than this appellant did.
When do you say that the asylum claim should have been raised?
Well, my lord, what I say is that doesn't really matter, so long as it was at a point before he did. I recognise that in the context in which this arose, it may not have been concluded to be incumbent on the appellant to make the claim back in 2014, 2015, very shortly after this alleged torture incident.
Before the coup, because there's a real question as to whether the torture was connected with his political sympathies at all.
Indeed. And that, my lord, is something that one would expect a tribunal to grapple with. So I don't pin my colours to the mast here. And I don't say that clearly that alleged torture incident should have been recognised at the time as being connected to the Gülenist incident.
The refusal letter does identify 2 occasions on which the Secretary of State says that he should have made his claim, that is to say 2016 and 2018.
Yep. And indeed, so I don't go beyond that. What I suggest is that at the latest, 2016, or what I suggest is that a tribunal should have grappled with this issue, specifically in relation to the 2 points at which the Secretary of State was basing her decision. In other words, 2016, the coup attempt, obviously well publicised, and which one might think would cause a committed member of the Gülenist movement to worry about his position and ventilate those concerns in light of the ongoing attempts to remove him from this country.
Now, at that stage, he had a human rights appeal going through the system.
Yes.
Just remind me what the position is if you want to claim asylum, because he wouldn't be able to do that, would he, in the context of a human rights claim?
What he would be able to do, I think I accept that. What he would be able to do, however, is raise human rights aspects of the claimed history.
So he might be able to vary it and claim Article 3 as well as Article
Indeed.
8.
Or yes.
It probably would be 3 and not 2, wouldn't it?
It
could be
probably
2
would.
even, but yeah.
But either way, it's not necessary to resolve this because there were avenues, and in any event, I would submit, the point is not just should he have raised these assertions, his asserted fear for his safety, through the prism of the ongoing human rights claim, necessarily, because it, of course, would have been open to him to make any asylum claim or protection claim in at the time that the asserted real risk of persecution or whatever came to his attention.
I'm just wondering, because, and this is a genuine lapse of memory on my part as to how it all fits in, but I seem to remember that the rules are a bit odd on what you can and can't do in terms of making new claims when you've got a claim which is already on foot. So if you've got an Article 8 claim which is passing through the system, and you then want to make, say, an asylum claim at the same time, I don't think you can make your asylum claim and park it. I seem to remember that you can't keep making different types of claim to the Secretary of State. You've got to
get a one-stop shop.
Yes.
So the one-stop, and I may have to take instruction on this because it gets very complicated.
That's what I thought, and that's why I asked you the question. I didn't want to get it wrong.
My understanding, and I hope I'll be pulled, have my gown tugged if I'm getting this wrong. My understanding is the one-stop shop principle requires applicants to raise all issues in one go, to the extent that those issues are within the knowledge of the applicant at the time.
Yes.
So that might have been an answer, but it's not one the FTT judge gave.
The essential problem, my lord, is that the FTT judge simply hasn't grappled with these issues.
And there might have been all sorts of answers to it. Perfectly good explanation.
There may have been.
It was the summons that was the trigger. He couldn't have done any. He couldn't have raised a claim any earlier.
Yes.
Couldn't have done it in the human rights appeal.
The point, my lord, is that the Secretary of State had squarely raised these issues. Mm. They were an important issue on the appeal, and
she didn't deal with them.
And she didn't deal with them, or well,
well,
not in any sort of coherent way, as the Upper Tribunal judge in my submission rightly put it. The way in which she dealt with delay made no sense. And if I could just complete the... We've departed slightly from the starting point. And
my fault entirely.
Not at all. It's of course helpful to address these points sort of as they naturally arise. But the point that I was going to make is that the Upper Tribunal judge squarely recognised at paragraph 23 that the First Tier Tribunal judge could properly have allowed the appeal, could properly have found that the claim was credible and that the delay didn't amount to anything. There was perfectly proper justification for it. The First Tier Tribunal judge could have done all of those things, as the Upper Tribunal Judge McWilliam recognised, but just didn't. The only place in my submission that the First Tier Tribunal judge even adverts to delay and the Secretary of State's argument that delay had a direct bearing upon credibility is at paragraph 12 of the determination. I've read it very many times. I know my lady has read it many times, but could I invite you to turn to it once again? It's at page 106. My lady, before I forget, I've just had instructions that effectively I was right about the way in which these, with the tribunal's permission, new issues may be raised. Page 106, paragraph 12. The court in the course of argument has recognised the disjunct here. It's right to say that the First Tier Tribunal judge starts by referring to the delay in claiming asylum.
Yes. But then says it's relevant in relation to the discrepancy.
Yeah.
Which it isn't.
Which it isn't. What is relevant to discrepancy, it seems, in the First Tier Tribunal judge's view, is that this happened over the New Year holidays. But then that, in turn, is not relevant to delay.
It explains the confusion about 2014, 2015.
Yes.
Which is a discrepancy that has been identified.
Yes.
And she says, well, there's an adequate explanation for it.
Yes.
Your point is that she doesn't deal with the broader point of delay, because that discrepancy is only part of the Secretary of State's reliance on delay.
I think actually that discrepancy is not part of the Secretary of State's case at all.
It's not. I'm not sure, however, and I do say that this paragraph is just completely incoherent, because in fact the judge then goes on in the final clause to say, or two clauses, but given that it's explained because it fell over the New Year holidays, I find less damages caused to his credibility by the delay in claiming asylum. That just makes no sense
at all.
No, it doesn't. And the Upper Tribunal judge was entirely right to put it in those terms. But this is the only part of the judgment in which the First Tier Tribunal judge grapples with delay and makes a hash of it.
I mean, the Secretary of State's case, as I understand it, is in paragraph 27 of the refusal letter on page 134. That's the point about delay.
Yes. Yes.
And that's nothing to do with 2014, 2015,
Nothing.
whether there was a confusion over New Year.
No.
That's all to do with subsequent events.
Yes.
And indeed, I think one's being charitable to the first tier judge. She does acknowledge that the thrust of the refusal is that this is a late claim for asylum, paragraph
Yes.
5.
Yes.
So she summarises the case for the Secretary of State on the basis it's a late claim, limited evidence to support, and he's low profile. So three prongs.
Yes.
She then goes on to the background and states exactly when it is that he made his application.
But then the only way that she actually engages and deals with those points on the face of the determination itself, at least, is paragraph 12. And so, as you'll have seen in my skeleton argument, there's an inherent uncertainty about what the First Tier Tribunal judge was actually doing. Was the First Tier Tribunal judge here saying, well, the only delay I have to worry myself with is the 2014 the delay from then, and I find for these entirely incoherent reasons that that doesn't damage credibility, or it causes less damage to credibility? Or was the judge, in my submission, that's so obviously incoherent that it's difficult, in fact, to imagine that that was the judge's reasoning on the issue.
But if you go back, sorry to keep harping on about the reason in the refusal letter.
Yes.
The refusal letter doesn't say you could have raised your claim in 2014/15.
It doesn't.
It says you could have raised your concerns regarding return at any time following the coup,
Yes.
which is 2016,
Yes.
as I understand it.
Yes.
So the Secretary of State is not saying anything about 2014, 2015. That's not what she That's not what she says at all.
Correct. What, of course, I can't say, I just don't know the answer, is whether or not the Secretary of State made any issue in relation to 2014, 15 in the hearing itself.
I don't think it's in the refusal letter.
It's not in the refusal letter.
Well, we've got a further problem, of course, that although she finds that his account is broadly consistent in his statements with what his wife said in evidence, paragraph 9, and so on, we've seen his witness statement, and that doesn't give an explanation for the delay at all.
No.
It certainly doesn't say whether his case has advanced on his behalf in the FTT was, as Upper Tribunal Judge McWilliam identified it. Well, I didn't fear for my life until my summons.
Yes.
Until the summons came in, and that showed that I was on their radar as a Gülenist sympathiser. That's not even articulated either, so you can't infer from her acceptance of his witness statement that she's accepted his explanation.
Yes. And I understand, of course, why Mr. Ball puts it in that way.
Yes.
There's also there's a basic circularity to that. There are several problems with that argument. First of all, there's simply no support for it in my submission on the face of the determination, the First Tier Tribunal's determination itself. But anyway, it would simply be wrong in principle in my submission for and entirely circular for a judge to say, well, I accept that the summons is genuine, And so I simply don't need to grapple with the issue of delay or give any reasons in relation to that, despite the fact that that's been squarely pleaded and is a principal issue in the appeal.
No, I think your position would be weaker, though, if the judge had said, I accept his evidence, and his evidence had given that explanation.
Yes.
And I accept that the summons is genuine and it's consistent.
Yes.
And I've factored the delay into account. I mean,
my position wouldn't. Forgive me.
It wouldn't be improved. You might still be able to make a point about the incoherence of paragraph 12, but you'd certainly be in a weaker position.
I can be entirely clear about it. If the First Tier Tribunal judge has said, I accept that the summons is genuine and therefore I don't need to worry about the delay because there may be all sorts of reasons for that, but in the end he's got a genuine summons which demonstrates that the Turkish authorities have connected him with the Gülenist movement, well, I'd be in real difficulties. But that simply isn't said. And
can't that be inferred from paragraph 13?
Well, that really is the matter for the court, but in my submission,
you say no.
Clearly not.
And the Upper Tribunal judge didn't buy that.
And the Upper Tribunal judge rightly didn't buy that in my submission. I probably don't need to make this point, but even if that could arguably be inferred, there is a duty to give proper reasons, and it shouldn't be for the left to the parties to try to work out and draw whatever inferences whatever possible inferences may be available to construct the reasoning and work out whether there may be viable grounds to challenge the decision.
Yeah, I mean, the only gloss on that, which I'm sure is right in principle, is that when looking at reasons, you take into account the fact that the decision is addressed to people who know what the issues are.
Yes, of course I recognise that. In any event, I probably don't need to make the argument. The essential, fundamental principle submission I would make is that it simply isn't available. It simply isn't available in force.
That's your point.
And moreover, the Upper Tribunal Judge McWilliam did not enter into an error of law in finding that it wasn't an available inference, or rather, that the reasons were insufficient.
No.
Oh, well, that raises quite an interesting point, perhaps. So, are you saying then that the question for us is not whether we think the FTT's reasons were or weren't adequate, but whether the Upper Tribunal was entitled, as a matter of evaluation, if you like, to decide that they were inadequate? There may be a difference between the
two. In my submission, the question for the Upper Tribunal Judge was whether there had been an error of law, which is, to some extent, an evaluative judgment, involves reviewing the First Tier Tribunal.
Of course, because the FTT gave reasons, and the question was, were they good enough?
Yeah.
And you can see that people might take different views on that. So what's our role?
Well, I certainly don't suggest that it's any sort of Wednesbury standard. The question for you is whether or not the Upper Tribunal Judge made an error of law, and the question for the Upper Tribunal Judge was whether the First Tier Tribunal Judge had made an error of law.
Did the Upper Tribunal Judge err in law in finding that the reasoning was inadequate?
Yes.
But quite often in a second appeal, we look at the first instance decision, whether it's a Housing Act appeal or a VAT appeal or anything, to see whether we think that the first instance decision, whether the First Tier Tribunal or the reviewing officer of the Housing Authority made an error of law.
Yes.
And we don't necessarily ask, did the first appellate level itself make an error of law? We go straight to the bottom, as it were.
it may well come to the same thing, because the Upper Tribunal judge cannot find an error of law, which is a question of law, if there wasn't one.
Yeah.
No. So basically it boils down to whether the reasoning was adequate or not.
Yes.
Yeah.
All right. Thank you, Mr. Chapman. Yes, Mr. Ball, any reply?
Yes, just very briefly. And starting, if I may, with a question which was rhetorically asked and answered by my lady as to whether the question was, is delay relevant to the discrepancy of 2014-2015? And my lady was of a clear view that delay wasn't relevant to that discrepancy in 2014-2015. Well, in my submission, delay was relevant, because the only way in which delay is relevant is the extent to which it affects or potentially affects credibility.
Yeah.
And it follows that the discrepancy about whether he went to Turkey in 2014 or 2015 is relevant as to credibility. Is he telling the truth about his account, bearing in mind that he's said one thing in one witness statement and another in another? So, in my submission, it is squarely the case that delay is relevant to that question about the weight that should be attached to the discrepancy given around the 2014-2015 issue.
Yeah.
And although it is inelegant, that is what the judge has done in paragraph 12.
Yes.
And then we come to paragraph 13, because, as I indicated, although we're talking a lot about delay, really it is a question of suspicious timing. That's the nub of the concern. And what the judge says in paragraph 13 unequivocally is the summons issued is consistent with the timings. So it is simply not fair to say that the FTT has not grappled with this issue, given that the FTT, looking at the determination as a whole, obviously had it in mind from the outset in paragraph 5. And then paragraph 12 weighs into the balance the impact of delay on the discrepancy and finds that it doesn't affect it much. And then squarely in paragraph 13 considers that the summons is consistent with the timings. And I emphasise that because the Secretary of State before you has said that when asked the question, when should he have claimed asylum, the answer is given is sometime between 2016 to 2018. And there we have the judicial finding that the summons is a consistent one. And if I could take you to paragraph 67 of my skeleton.
57, did you say?
67.
67.
There in my submission is the structure of a judge's reasoning.
Yeah.
So, to answer the question that was posed from the bench, did the Upper Tribunal err in law by finding that the reasoning was inadequate? In my submission, the Upper Tribunal did, because, as set out in paragraph 67, there is a logic and a structure to the reasoning, albeit it may not be perceptible at first reading, and albeit that last sentence of paragraph 12 may not be immediately apparent after a number of readings.
But shouldn't it be perceptible? Isn't that the whole point about sufficiency of reasons? It's got to be sufficiently perceptible to the person who knows that they're losing.
And the person in my submission knows why they are losing when the judge says, in terms, that the summons is consistent with the timings. And that is against a whole backcloth of credibility findings, some of which are positive, some of which the judge identifies that there are areas that are lacking. But where the Upper Tribunal judge has fallen into error is by, as I've indicated, requiring Section 8 to have been a compartmentalised assessment rather than something that suffuses credibility as a whole. And that's why, although this is couched as a reasons challenge, it is in effect a bit more than that. If I could invite you to turn up how the Secretary of State put its case in the grounds, page 96. Five grounds are advanced. And it's the first which is found favour, but they're all under the heading making a material misdirection / lack of adequate reasoning - consideration of credibility. And my lady says, well, this needs to be understandable to the reader in the context. And I accept, of course, that permission was granted by the Upper Tribunal on that first point. And obviously, the Upper Tribunal went on and found against. But I do pray and aid for the determination of the First Tier Tribunal when considering this application, which is at page 101. Where as far as Judge Saffer of the First Tier Tribunal was concerned, the grounds amount to nothing more than a disagreement with the decision. Section 8 was appropriately considered. And pausing there, whilst I've taken you to the grounds that were before the Upper Tribunal, the grounds that were before the First Tier Tribunal, consideration by Judge Saffer, were identical. My lady, my lords, unless I can be of any further assistance.
Thank you very much, Mr. Thank you both very much for your arguments. We will reserve our judgments. You will get a draft in the usual way. It comes with an embargo, which is very fierce and must be obeyed. The solicitors will be responsible for distributing the draft judgment to those people who are entitled to see it and to no one else. The reception of the draft is your opportunity to correct our spelling and our grammar, but not our reasoning, nor to raise any new points. And we would hope that in the light of the draft you will be able to agree an order disposing of the appeal, but if there is no agreement possible, please make short submissions in writing and we will make the formal order that we consider to be appropriate. Thank you very much.